Hello everybody. Good morning, good afternoon, good evening, good night for some of our participants. Everybody very welcome to the International Law Institute and our seminar on food security, resilience in the face of crisis, building back better. My name is Gerard Botha. I am the Director of Program here at the ILI. And it is my privilege to welcome our course advisor, Ms. Jeanette Trammell, to the seminar as our presenter. She is the course advisor for our food security related seminars, one coming up in March, one coming up in July, and we invite you to visit our website at www.ili.org to see more about these seminars. But today, Jeanette will be our presenter in the webinar. She is a senior legal officer at the Organization of American States, OAS, and has decades of experience in trade law, commercial law, and in particular, in food security issues, and she's worked with communities in Southeast Asia, Central America, the Caribbean, on complex projects related to food security and sustainability, very important. Jeanette has degrees in agriculture, in environmental design, and in law, both at Queen's University in Canada and here at Georgetown, graduate degrees in law here in Washington, D.C. So without further ado, Jeanette, welcome. And yes, a housekeeping matter, I almost forgot. Colleagues, due to the number of people that may join the seminar, we have a lot of applications. You will be muted, your computer will be muted, and the videos will be turned off. So if you have questions, please use the chat function. I'll be monitoring that. And at the end, we'll put the questions to Jeanette and we can have a discussion for those who would like to stay. Thank you very, very much as always. And Jeanette, the floor is yours.
Thank you very much, Gerhard. First, as a housekeeping matter, can you hear me? The volume is good? Okay. I can just even turn that up a little bit more. Good morning, everyone. Good afternoon, good evening, as the case may be. It's an honor and a pleasure to be here with you to speak on this important and critical topic, one that has been of longstanding interest and passion for me. I know we are still living through very challenging times, so I hope that you are safe, you and your families and loved ones are safe and healthy during these times. I must begin with a caveat that these comments are made in my own personal capacity, do not reflect the position of the Organization of American States or the Secretariat. With that out of the way, let us begin here with an outline of how I would like to present today. I'd like to explore with you how private international law can be used as a vehicle for achieving Sustainable Development Goal number 2 on ending hunger, improving food security, and moving towards sustainable agriculture. After a brief look at the current situation, we'll consider how private international law can be used to address immediate concerns, specifically supply chains and keeping supply chains open, and then looking at some longer term solutions. I'd like to take this in the context of Target 2.3 with Sustainable Development Goal number 2 and look at these particular areas and new developments in these areas and how these can be of assistance in terms of moving towards the actualization. Of course, this is the International Law Institute, and so that is the discipline and the lens through which we look at these issues. But the pedagogy of the Institute takes a pragmatic approach. As we know, these complex issues of sustainability and food security definitely need to take an interdisciplinary approach. Gone are the days where we can have the trade lawyers in one room, environmentalists in another, economists elsewhere. We really need to bring people from different disciplines together. And that is what we like to do here in the course. And I'm happy to see that in the webinar as well, that we have a diverse group of participants to be able to thrash out these issues together. But that having been said, it does make it a bit challenging in this type of context to be able to address a diverse audience. So while we generally do try to make a point of tailoring the course to the needs and interests of the participants, without being able to do that today, what I'm hoping to do is to introduce a few different ideas without going into each of them in any great depth. So let's begin then with the current situation and some of the updates since the pandemic began. Most of you will already be familiar with these figures here, that to reach the projected figures for world population in 2050, it's estimated that we need an increase in food production of about 50%. And now why 50% if population is increasing by about 26%? Because of the dietary shifts that accompany economic development and urbanization towards more livestock-based products and more convenience-based foods. But at the same time, we know that about 1/3 of all food that is produced is lost or wasted, and that agriculture both contributes to climate change and is impacted by climate change. So it's widely acknowledged that change is needed in the way that we produce food globally, that there's a need to be able to reduce global emissions and at the same time increase food production, and that this requires a significant transformation in our global food system. And there have been a number of studies in this regard, and I'm sure that you are familiar with them. So the question for us today really is, how can we use law in that endeavor? As you will be familiar, the COVID pandemic really revealed some of the weaknesses in the current system, particularly with respect to supply chains. Who can forget the images that we saw from around the world early on in the pandemic? In countries at all levels of development, supplies piling up at farm gate, while grocery shelves remained empty. And these were supply chains internationally as well as domestically and at local level. The World Bank 2020 review estimates that the COVID pandemic has pushed about 88 to 115 million more people into extreme poverty. This is the number of people who are living at less than US $2 a day, which is incidentally the amount of money that you require for a healthy diet. Depending on the forecasts used here, we have the different possibilities of the baseline or the extreme, but in any case, we know that there are more people being pushed into poverty. In terms of hunger levels, already in 2014, after steady declines, hunger levels had been starting to increase at annual levels. And at the end of 2019, even before COVID, hunger levels were higher than usual for a number of different reasons. This is based on the SOFI report of 2020. Of course, the official figures always lag. The global update, global report on food crisis that is issued every April will be the one this coming April that will really give us the data that will reveal the true impact. But nevertheless, we know that pandemic has pushed those who have been at the cusp of acute food insecurity into the acute category. Although the concerns over a global crisis seems to have abated, the primary risks are largely at country levels. And as you can see here from this, from the World Bank brief in December, 2020 marks the most severe increase in global food insecurity impacting vulnerable households in almost every country. So it's essentially patterned in that respect. Underpinning the goals that are set out in SDG number 2 is the right to food. Although the SDGs represent a common vision, the right to food by comparison does correspond with certain legal obligations and responsibilities on the part of states. and it has even been incorporated into the constitutions of many states. Its articulation has evolved over time from that you see here in the original 1948 declaration, and is now recognized that states have different levels of obligations, from the ensuring the fundamental right to freedom from hunger and malnutrition, but while the right to adequate food is something that will have to be realized progressively. This has resulted in something called the voluntary guidelines to support the progressive realization of the right to adequate food in the context of national food security. Quite a lengthy title, and I should have put that up on the screen for you, but the voluntary guidelines are a significant document in this respect. Here is then SDG number 2, with those right to food underpinnings. The right to be free from hunger corresponds obviously to the first goal, to end hunger. And then here we have as well the definition of food security, which has been evolving, and this is the one that we refer to, although there are a few different interpretations. This also derives from the right to food, specifically from something that is referred to as General Comment number 12 on the International Covenant on Economic, Social, and Cultural Rights. And it also gives rise to the 4 pillars of food security: availability, access, utilization, and stability. We see here also the reference to sustainability, when all people at all times have physical, social, and economic access. So in other words, food security for present generations must be achieved in such a way so as not to jeopardize that of future generations. And we consider that in a global perspective as well. We can't have food security for people in some parts of the earth and to the disadvantage of others. So of course, for states to protect, respect, and fulfill the right to food is fundamental, but it leads us then to the question of how SDG number 2 is to be operationalized. So to help with that are the SDG targets, and in these next 2 parts 2 and 3, we'll consider these targets and how international law then can be used as an instrument towards that actualization. Just excuse me, take a moment here. So let's see now in terms of addressing our immediate concerns. At the beginning of the pandemic, there were concerns that actions might be taken on the part of governments that would precipitate a global food crisis, similar to what had occurred in 2007. As you may recall, at that time, there were a number of countries that had started to impose export bans, and then that led to a precipitated cycle in increased pricing and precipitated a global food crisis. So the recommendations that came out of the this joint statement in the spring was to ensure that we keep global supply chains alive and open, in addition to measures to protect the most vulnerable. And of course, to do so in a way to maintain and encourage international cooperation. So here we have an update most recently from the AMS monitor, and the agricultural market information systems is something that then came out, I believe, was a result after the 2007 global crisis, to ensure that there would be free information flows to prevent that type of incident from happening again. So the report here we have in December indicates that although there is resilience in global food markets and supplies are good at this time, there's increased vulnerability to food security because of diminished purchasing power and disruptions that still continue in domestic supply chains, even if international ones can be addressed. So in other words, there is still this shadow of food crisis, but rather than more of a global threat specific to particular countries at this time. But let's consider for a moment here the domestic supply chain from farm to fork within a state, and consider a particular product such as potatoes or beans or rice. And so some aspects of the process will fall within the realm of what we might call public law. For example, there's likely to be environmental laws that govern the use of pesticides. There might be labor laws that specify a minimum wage for farm workers. Other aspects would fall into the realm of what we would call private law, such as the law of contract that governs various agreements along the chain, such as the employment contract with farm workers, the contract of sale between the producer and buyer. So until there is actually a contract, in a sense, the minimum wage doesn't have any immediacy. The contract operationalizes, if you will, a minimum wage requirement is something that is that represents a goal in society for decent work and a decent fair wage. So therefore, there's this interplay between public and private law. Now, if we take that same example, that sale of potatoes, and make it a transnational one, this adds, of course, a layer of complexity. So some aspects of production will continue to occur completely within the sphere of domestic law over here. And other aspects then will include the international component. The potatoes might be grown under a contract, under a contract farming agreement, a purely domestic contract, or they may be the subject of an international contract of sale. The parties will have to consider various border issues, possible export or import restrictions, phytosanitary requirements, the tariff rate for goods. So at each step of the supply chain, there are both what we would call public international law and private international law issues. In the realm of public international law, would consider international trade law governed by the WTO, the Agreement on Agriculture, on health and safety issues, standards such as those of the Codex Alimentarius, which are then introduced in domestic regulations. In the realm of private international law, there might be elements of something, the Vienna International Convention on International Sale of Goods. So we need to look at both of these areas, both public and private, and in both the domestic and international realms. So just a brief refresher here on private international law, with apologies to the experts in the audience. Traditionally, this has been limited to conflict of laws. So if you consider that there might be a contract between individuals, so natural persons, or there may be a contract between what the law calls legal persons, two companies, or even between a company and an individual person. In any case, which is the law that governs? Would it be the law of contract in the state of the seller, or would it be the law of contract in the state of the buyer? This was traditionally this field of conflict of laws. But today, now with this more expanded understanding of private international law, we consider this to be the body of law that regulates those relationships between parties in different states. And as we will see, there are different conventions and soft law instruments, guides that can help us in this respect. So then in terms of keeping supply chains open, it has both the public and private law aspects. Governments may decide to impose export restrictions in the form of a tax or ban, which is, as I mentioned, what happened in 2007, where rice exports were restricted and led to an upward spiral. Thankfully, that has not happened with respect to foodstuffs, but if you can see this policy brief here on food export restrictions, there have been certain restrictions with respect to COVID on personal protective equipment. But what if a government did impose such an export ban? When we go back to our contract of potatoes, of sale of potatoes, for example, or rice, could the seller claim frustration? Could the contracting party invoke the pandemic or a governmental measure as an excuse for non-performance, or as a request to renegotiate the terms? What are the consequences for that private contract? There's this interplay again between public and private international law. So at the domestic level, such situations are normally discussed according to traditional concepts such as frustration or act of God. But again, in each state, there may be a different solution. So to encourage a more uniform approach to this, we have the UNIDROIT Principles on International Commercial Contracts, which offer a comprehensive set of general rules that are applicable to different types of contracts. And these principles are generally used now in a number of ways to provide some kind of a uniform interpretation. And on this particular issue, the UNIDROIT principles do have something to say on force majeure and hardship. And more recently, UNIDROIT has released a note on the principles and the COVID health crisis to help parties use the principles during the pandemic to see how they could be used in interpreting some of these aspects to guide parties and adjudicators through the process, and whether parties might invoke COVID as an excuse, and if so, based on what concepts and under what conditions. Similarly, we have another example here from ILADI. These recommendations were made in July, and as you will see in the preamble, they note that the pandemic has given rise to circumstances that have led to frustration or impossibility of performance of international contracts. And so in their recommendations, then they do make reference to these soft law instruments. In the second one, the UNIDROIT principles, which we just noted. And then in the first paragraph, reference is made to an OAS instrument, the Guide on the Law Applicable to International Commercial Contracts. So these are recommendations to these soft law instruments that can be used in terms of addressing these kinds of questions by looking to international standards that are available then to the private sector for guidance. So again, we see this interplay between the public and private regulation and private contract. Both can operate conjunctively to keep supply chains open. So then if we turn now, I think I will turn to ordinarily what I would like to do is to be able to stop and see if there are any questions at this point, but we will, in this format, we will continue with our third part. What I'd like to do is to consider now, having looked at the more immediate concerns, how can we use private international law in terms of building back better, taking the longer view? Excuse me a moment. So how can we create a thriving agricultural sector? In one state or even a farm, one might have the benefit of excellent biophysical components, rich soil, ample water supply, and yet another state with the same kinds or very similar advantages is not thriving. And why is this? Because it's not sufficient to have both only the biophysical ecosystem, the financial, and I should have put here, financial and legal ecosystem are equally important. Now, what do we mean by that? It includes, this financial and legal ecosystem includes access to credit, insurance, crop insurance, warehouse financing, and so on. This is the focus of a lot of the work of the International Law Institute, is to look at those areas of the law, and often through law reforms, in terms of how we can strengthen that aspect, to strengthen and modernize that part of the ecosystem. Now, this slide isn't as colorful as the one of the slide with the oranges, but of course, this side is equally important. So you will recall at the outset the brief background that I had introduced as the challenge that we face to reduce global emissions and at the same time increase food production, and that this will require a radical transformation of the global food system. And so these goals then to end hunger and achieve food security are inextricably bound up and must be contemporaneously pursued with respect at the same time as we try to shift towards more sustainable agriculture. So we can look then at the targets that have been identified in terms of how we can try to move in that direction. So we have here targets 2.1 and 2.2. try to deconstruct each of these targets through a legal lens. What are the relevant legal underpinnings, the international law, both public and private, domestic and international, and are there barriers or restrictions that need to be addressed? For example, and then we have here targets 2A, B, and C. B is addressing really the trade issues here. And as you can see here, the elimination of all forms of agricultural export subsidies. In 2015, already in Nairobi, under the Doha round of negotiations, WTO member states had committed themselves to removing and abolishing export subsidies. So that might be an aspect already of this target that we might consider is quote unquote done. So export subsidies do not seem to pose the same threat to trade distortions and distortions in prices that they have in the past, but notwithstanding other forms of restrictions. But this is an example of the sort of thing that we would want to examine, although I'm not going to focus on trade today. What I would like to do is to look at target 2.3 a little bit more detail and just look at a couple of aspects of this. Now, there you see on the screen the report by the World Bank, the Enabling Business of Agriculture, which measures progress and identifies regulatory obstacles to entrepreneurship in agriculture. Of 8 indicators, 1 is access to finance. And there are 2 aspects of that, the indicators that are used, warehouse receipts and inclusive financing. So let's look at those 2. For the small farmer, the biggest asset, particularly for those who don't own their land, is probably the crop. But often the producer has no choice but to sell at harvest to meet immediate cash needs and to be able to obtain the products, the inputs for the next season. But at harvest is when supply is abundant and prices are typically at their lowest. So what a system of warehouse receipts financing enables is for growers to be able to store their crop and use that as collateral to pay in order to obtain cash to meet immediate expenses, and then sell later when prices have improved. But in order to do that, for an effective system, lenders need to have confidence in the collateral. And so that means first that the physical warehouse infrastructure needs to be one that there is confidence in that with the third-party inspection, and also that the legal infrastructure is in place. And on the screen, you will see several initiatives in that regard. We had the FAO study in 2014, the World Bank study, and then in 2016, the OAS had produced its principles for electronic warehouse receipts. And currently, there is a joint initiative underway between UNIDROIT and UNCITRAL to develop a model law for warehouse receipts financing. The working group has just started underway. So this is an area to watch. We will be seeing more development of a legal instrument in this important area. So let's then look at the second aspect in this study that the World Bank reviews on inclusive finance. In recent years, well, let me start first by asking you, consider your credit card and the interest rate on that. Most likely, 20, 23%, different from other loans on a mortgage, running usually around 5, 7%. So why is the interest rate on, say, a credit card so high? It's because it's unsecured. If you default on that loan, the bank has no collateral. So it's an unsecured loan. So here, what we're talking about is secured lending, something of a collateral that the bank will have in the event of default, which is a way to minimize and reduce interest rates. So in recent years, a number of countries around the world have initiated reforms to create a more modernized and effective and streamlined secured transactions regime based on one of these models. We have the OAS model and then the UNCITRAL model. And this extends the range of acceptable collateral to include what is referred to as personal property, or in some cases, movable property. goods other than land, so equipment, inventory, receivables, which for many small businesses is the real source of what they have, their collateral. And the domestic examples, many of you would be familiar with the UCC Article 9. In Canada, we have the Personal Property Security Act in different provinces. So then you may ask, well, what does this have to do with inclusive finance? How can this achieve equitable access to finance? And what I would like to do here is to share with you a video about from a project that we did at the OAS, just a few minutes on this, a secured transactions reform initiative in El Salvador. It is in Spanish with English subtitles. It's just a few minutes, but you do have the link there, so you'll be able to see this later on your own. So I'm going to have to end the screen, and then I will take us to the video here. No, I wasn't able to.
Yo como mujer les sabré decir que así como nosotros, que no contamos con garantías, sí tenemos limitados para accesar a un crédito. Como cooperativo con lo que contamos es con un comodato, tal vez un horno. Eso es lo que nosotros podríamos presentar.
La documentación, pues la normal que uno tiene, pero las garantías que piden como referencias personales o fiadores, eso es lo más difícil. Si no tiene algo que dar de garantía como una casa, o sea, no le dan crédito a uno. Las tasas de interés son demasiado elevadas.
Desde 2013, el Departamento de Derecho Internacional de la Organización de los Estados Americanos, OEA, ha venido prestando al gobierno apoyo técnico en el ámbito del fortalecimiento de las capacidades en la revisión y reforma del marco jurídico que rige sus operaciones.
El proyecto
There, so I hope you enjoyed that little excerpt from the video. I think why I wanted to show this to you, because I think it was so important to hear in the voices of the women themselves. And what was it that they said? That we don't have land. We can't get a loan. We don't have a house. We can't get security from the bank. And this is in the case in many states, that women often do not own land, either because they're not legally able to hold title or culturally it's not accepted. So the secured transactions reform, as you could in the model laws and the reforms that have been initiated on the basis of these models, by expanding the range of collateral, we improve access to credit for those who need it most and who have not had access, marginalized groups. And so this is the way that it takes a step towards inclusive finance. But is that enough? Consider for a moment that over 90% of MSMEs, medium, small, and micro enterprises, exist and operate in the informal sector. If you have an informal business, can you access formal credit? It's unlikely. So you're either then precluded from credit entirely or at very high rates of interest. So you can see here the rates of informality are really very significant. But why is the informal sector so prevalent? What happens when laws are not modernized, not updated? In many states, starting a business is extremely complex. And so if it is complex, that means either that it's going to be very expensive, or you need a high level of skills, or you need to have a third party, a lawyer, a notary, an accountant to set up the business for you. But people have to see if I can go to the next slide here. People have to make a living somehow anyway. So what do? They still start a business. They start a business anyway. They create their business. They start their business outside the formal legal infrastructure in the informal and start an informal business. So in many jurisdictions where the law has not been updated, it's no longer useful and acts more like a hurdle, a formidable structure that serves an increasingly smaller segment of society. So to address that need at the OAS, we have developed the model law on the simplified corporation. It's the first international instrument that contains the major elements commonly recognized as critical for simplified business registration. And then here at UNCITRAL, let's see if I can bring up our highlight. At UNCITRAL in Working Group 1, they have been working now, the work is still in progress on a draft legislative guide on a limited liability organization, but they are looking at the entire life cycle of the business. And as you can see here in the quote, most businesses in the world are micro, small, and medium-sized enterprises, and they are the backbone of many economies. So if we can assist in the formalization of these businesses, it will enable them to better obtain access to credit. And you can see here in the World Bank Doing Business, in the ease of starting business is one of the 12 areas that is monitored in business regulation because it's widely recognized that this is so important. And as we know, the Sustainable Development Goals are indivisible and integrated. So here we see the reference to SDG number 8, which is on decent work, and target 8.3 encourages formalization of businesses. So all of this needs to really, really operate together. And why formalize? Of course, as you can see here, there are many benefits to both individuals and to government and society as a whole. But the reason I bring this forward today in this context is because it improves opportunities for access to credit. And as we know, access to credit is a way of helping MSMEs climb the value chain. But while formalization and access to credit are broadly applicable to MSMEs across industries, what I'd like to do here now is to look specifically at a couple of instruments that are specific to the agricultural sector and look at the topic of contract farming. Many of you in the audience will be familiar already with contract farming agreements. They're increasingly being used as we've seen the global transformation towards a more international supply chain. It's an agreement made in advance, so rather than waiting until the produce is produced by growers, it's made in advance of the season and specifies the terms, and the terms often also include specific production methods. But as you can see here by the former UN rapporteur on the right to food, whether contract farming is used in a way to actualize the right to food will be very much dependent upon how it is used. Because there are certain advantages and disadvantages for the buyer or the contractor. They can exact more consistent supply and quality, but they may face higher transaction costs. There's risks of side selling or misuse of inputs by producers. For producers, for growers, it may lead to more stable and better incomes. They gain access to markets, global markets. They also gain access frequently to technical advice and training. But the risk, of course, is that it may exclude smallholders, risk of increased indebtedness if they are in a situation where they need to borrow to be able to try to move in this direction. So for example, if buyers have more stringent requirements and they push these requirements down the supply chain, then often it is only the larger or more sophisticated growers that can take advantage of that. There's also the risk if growers shift away from subsistence crops into cash crops for export. What does this mean for local communities? Will growers still be able to use, to divert some of their crop for local sale? Are concerns of women addressed? Because women often will be tend to subsistence crops for the family, and then if they are also required to participate in the maintaining of the cash crops, will they be able to do both? So therefore, we have these guidance documents that have been prepared for contract farming. We have the UNIDROIT legal guide to contract farming of 2015, and the model agreement for responsible contract farming that has been developed. From these guides, we see that several principles should be included in the negotiation implementation of agricultural production contracts to ensure that a participatory approach is taken to empower those who are participating in this. And often it is growers will work through a farmers cooperation, a farmers association, to be able to take part in that respect. Very important to include women, of course, in that process, and the potential consider the potential impact and that in respect to the realization of the right to food. Looking at this model agreement here, I just pulled out a few highlights, a few aspects of this agreement and the commentary. As you can see here, because often it is the woman who is performing most of the work, to include women as a party to the contract is one of the recommendations. And also here, one of the key points, in order to try to promote environmentally sustainable agricultural production, to encourage this as well and include this in the contract itself. So subsequent to the legal guide, we had the development of this enabling regulatory framework document, which is aligned with the contract farming guide and the RAA principles, the principles for responsible investment in agriculture and food systems, which were approved by the Committee on Food Security in 2014. We refer to these as the RAA principles. So although contract farming is generally associated with foreign investment and export agriculture, it can also be used in local context. So this regulatory framework is a document then that addresses more the regulatory aspect, whereas the 2015 legal guide looks at that bilateral relationship. So the legal guide on contract farming and the model contract farming agreement are primarily directed towards that bilateral contractual relationship between the private parties, the buyer and growers. This document provides guidance to domestic legislators in terms of how to appraise and evaluate the domestic framework and possibly reform specific areas of domestic law. Responsible contract farming can be a powerful tool for smallholders and help them move towards larger scale commercial production, and thereby it can promote and encourage economic growth and contribute to that supply chain efficiency that we were talking about earlier through the production of higher qualities, of better quality in terms of the products, and contribute in that respect to domestic food security. But to do that, we really need that healthy legal and financial ecosystem. And we recall the diagram that I had indicated at the very beginning, and these different aspects that will contribute towards that. So in summary then, returning back to target 2.3, I hope that this brief overview has indicated to you and helped to identify how there are these different aspects in terms of access to credit, formalization, and contract farming that can contribute towards this, this particular target, so that these marginalized groups will have access, secure and equal access. We didn't look at land, but we looked at financial services and markets. So that is an example, I think, in this respect we didn't look at any of these in any particular detail, but I thought it might be useful to look, just to provide an overview and look at these different aspects. And trying to illustrate thereby, we come back to our international supply chain. We can see here our international law and domestic law are intertwined. Sometimes where domestic law may be weak, for example, in environmental law or other areas, labor law, we can turn then to standards and soft law instruments that we have in public international law, the right to food, the VGDT, the voluntary guidelines on governance of tenure, the RAE principles, responsible principles on agricultural investment. So these are ways that public international law can serve as a gap filling, or in other respects where there is actual connections between these two. Similarly, in the private law area, I gave examples there. We had the UNIDWA principles on international commercial law that can act as a way to provide an international standard when we look at interpretation of private contracts. So again, we have that interplay between public and private, between international law and domestic law. But then also, I think we can see the interplay between public and private international law. This was in a way to try to illustrate how all of these need to be working together to operationalize the goals embedded in public international law, with the examples that we looked at in the areas of access to credit, some insights in terms of how we can use private international law towards the actualization of Sustainable Development Goal number 2. So I would encourage you to go through the same exercise in relation to other SDGs. We can look at that in terms of water, health, look at the targets, and then consider and identify what areas of the law are relevant, whether this is in the field of domestic legislation or international law. Are the laws working in service towards these ends, or do we see that they are acting as barriers? So that essentially concludes my presentation today. I would like to leave you with that note that law is an instrument for change. It's an instrument for positive change. And with that, I would like to turn it back to Gerhard and see if we might have some questions and open for discussion. Thank you.
Yeah. Well, thank you, Jeanette. And again, just to mention, there's a lot more, of course, a lot more depth. And again, I invite you to visit our website to look at the courses in March and July for those who are interested. But they're interesting, just a comment, first of all. Jeanette, maybe can you access the question and answer? Because Bob Tansey gave a very interesting comment here. Let me read it. It's not going to be as Bob, apologies. I'm sure you would have done it better. But he says it's more a comment than a question. A global shift. It's a very interesting and relevant comment, I think, to the topic today. A global shift towards regenerative food systems can promote healthier soils and long-term resilience, provide climate mitigation and adaptation benefits, increase water retention, and prevent harmful runoff. Legal and other efforts to promote tenure rights, inclusiveness, equity, and access can make it easier for small-scale farmers to adopt methods with broad societal and planetary benefits. And thanks in regards. And I want to add to that a question related to human rights, if you will, Jeanette. You mentioned, whether contract farming contributes towards the actualization of Sustainable Development Goal 2 as dependent on human rights, human rights-based approach. So these are very closely related. So maybe just going to Bob's comment and maybe just saying a little bit more about this human rights aspect would be very interesting. If you just have a moment, please.
Yes, thank you very much, and thank you for that comment. Indeed, there are so many things that we can look at in terms of trying to make this shift towards a more regenerative approach to agriculture. And this does beg the question, you know, what is, we didn't have time today to look at this, what do we mean by sustainable agriculture and promoting sustainable agriculture? There are many aspects of this. We talk about many different terms that are used: organic agriculture, regenerative agriculture, permaculture, agroecology. There are they certainly overlap. Each one would say that we are, you know, this is sustainable agriculture. There's certainly different elements in that. So that is certainly a very interesting area that needs to be unpacked. And in the years, I think in the time that comes ahead, we will see how these, and we do have international legal instruments that give us some clues in this respect as well. So this is really critical. This is very critical indeed. In respect to the actualization of SDG in terms of its dependent to using a human rights-based approach, is because essentially a contract farming arrangement is essentially a private instrument, agreement between the buyer or contractor and individual producers, sometimes a cooperative. And the guide provides guidance on that bilateral relationship in terms of ensuring that it's based on principles of fairness, good faith, transparency, but it operates within a regulatory environment. And it is that environment that can set the standards and goals. So with states having the obligations to meet the right to food and in a progressive way, we can work towards that in terms of trying to make the necessary amendments to domestic laws, ensure that the contract farming is governed by appropriate legislation, ensure participation, accountability, non-discrimination, transparency, and human dignity. The shift to cash crops may impact food security of the particular producers involved, but also of the country as a whole. And so therefore, it would be really ideal to consider contract farming within the framework of a national plan for food security, which is one of the recommendations of the RAE principles, particularly RAE principle number 35. So I don't know if that can help in terms of, it's sort of an example of how the bilateral relationship fits within the national context.
Thank you, Jeanette. I think there's another question related to the sustainable agriculture, contract farming, and conventional farming systems. So how could contract farming encourage a shift towards sustainable agriculture if it's still based on conventional farming systems? Can you maybe just speak to that a little bit?
Yes, and that is a really a very critical point too, because we see a lot of we had seen a movement towards a contract farming, and this can move towards more monocropping and as a risk to biodiversity. So the way that we can use contract farming and encourage a shift, I mean, if contract farming is something that it certainly is very important and used significantly globally right now. So why not use the strength of that? Use the strength of that to make the shift towards sustainability by incorporating those sustainable agricultural practices as a requirement. Practice such as agroecology and the resilience that is needed. So both at the legislative level and embedded into the contract. By offering training and technology transfer. There are examples of how this, so we can actually use that mechanism and the strength of the vehicle of contract farming as being so prevalent to encourage that shift towards sustainability by including sustainable practices as a requirement in terms of the domestic legislation that will require that to be embedded in the contract. And it's a better option in some ways there's an example, I believe, in Brazil, where the law governing contract farming operations does place upon the parties an obligation to include clauses on environmental responsibility in the production contract. And, another option would be, this is perhaps a better option, or another option in terms of, rather than encouraging land purchases. So contract farming is a way that smallholders can retain their land rather than selling it. And so that can encourage a shift towards more sustainable practices on their part as well. So encouraging more market access at the same time as maintaining their land holdings. I hope that addresses the question.
Thank you, Jeanette. There are also some questions on certificates and on posting and so on. I'll go to them in a moment. I just want to acknowledge Sylvie. You make an important point. I think maybe you missed the beginning of the presentation. You say that agriculture has a technological aspect. It creates a problem for developing countries, of course. Very, very real, very relevant. How do you think international law can address this issue? That was the second part, but you also have at a first part where you emphasize the interdisciplinary nature of this whole venture. When we focus on food supply, we are giving importance to the economic nature of food security, but food security is a concept of interdisciplinary nature. So I think that was a point that Jeanette made very strongly at the beginning of her presentation. But this technological aspect, creating problems for developing countries, how can international law address this issue of access, really, not just to finance, but I guess to technology and other aspects as well, is embedded in Sylvie's question.
Mm-hmm. Yeah, I'm not quite sure that I was following there in terms of, yes, access to technology is that the question that this is?
I think it's another emphasis in terms of the challenges that developing countries face that Sylvia is pointing to.
Yes, and certainly that is one of the benefits and advantages with contract farming as well, is that that can be an important mechanism in terms of providing access to technological means and new technologies. Yes. Mm-hmm.
Okay, so just bear with me here for a moment, and then Stefan Meyer from Australia. Good morning, Stefan. Good afternoon. Are there any international soft law instruments on food waste?
That is a very good question, and I have to say I don't know. we need to. That is certainly an area that we need to. There has been a lot of discussion about that, but I don't know whether there are any international soft law instruments. Let me see if I can get back to you on that. If we will make a note of your question and respond. Certainly there, and that is also within the, I think it's 12.3, the SDG target 12.3 in terms of trying to reduce waste generally. We might also consider in the Milan Urban Policy Pact, one of the things that we didn't have an opportunity to talk about here today was urban agriculture, which is a very important part of the whole shift towards more sustainable global systems, producing food where people live, and at the same time trying to integrate waste management into that process. And it might be worth looking into the Milan Urban Food Policy Pact if there was some mention there. Now that's not an international soft law instrument per se, but there might be some mention of addressing food waste in that initiative. A very good point.
Thanks.
Thank you.
And we can maybe follow up on that. That is a good point that can maybe be posted later. Thank you, Jeanette. And then a very, I think also a delicate, very interesting and important point made. II-10, access to credit is still very challenging for Rohingya communities in Myanmar due to various reasons. documents, lack of documents, travel restrictions, and so on, restrictions posed on microfinance institutions. How can MFIs imply flexibility in terms of that situation? So I guess it's, there's some political and other practical challenges that also enter into this equation. I think maybe the underlying point there, Jeanette.
Yes. Well, it's true that there are so many complicating factors in terms of trying to ensure access to credit. This is only one that we were looking at here, but certainly it is one important vehicle that is sort of a cross-cutting one, is to be able to, at least to be able to ensure that the law is in place so that smallholders and small business persons can use whatever collateral they do have available to them to access credit. Of course, there are other means, like microfinance is another option to that. But certainly within the context of many countries, there are other restrictions and difficulties that do impose challenges to accessing credit that I'm not really sure how we can address those.
Okay, and then again, an opposing question to contract farming from Parth Gupta. There have been cases where contract farming has been firmly opposed by the farmers like India. Then in such a case, a question, how can resilience be achieved?
Mm-hmm. Yes, a very good question. And contract farming is not the only way, of course. It was, I think the example that I was giving here was trying to say, okay, if contract farming is one that a method that's going to be used, how can we ensure that it is done in such a way to ensure that it is used in the service of achieving and actualizing right to food, done in such a way that it's in the service of ensuring food security for the community, for the country, in which it's taking place. But contract farming, of course, is not, as you point out, it has been opposed in some communities, and it's not the only means that can be used towards achieving food security. There are other ways. Certainly there are ways where parties can look towards farming cooperatives. There are direct and immediate, the former types of transactions between buyers and growers, and trying to, again, look at legislation and see if there are ways of introducing technical training to improve capacity building, other mechanisms that can be used as well.
Nice, thank you. And then Sylvie, I think this is our last question. I see we just over 9 o'clock, well, here in the US, under 9 o'clock. So we promised to keep everybody away from other things for an hour. We don't want to go too far over. People have schedules, we know. But this is also a very interesting point from Sylvie, which is addressed in the main seminar too, by the way, Sylvie. In contract agriculture, there is a food safety issue, and every country has their SPS measures. Can it create a problem for the seller's exporting person? So the food safety, as I think, is another layer of complexity, if I may, Jeanette.
Mm-hmm. Yes, certainly that is an aspect, and so that can be challenging. I think that was an example of sometimes the buyer requirements that are pushed down the supply chain. So a retail outlet, in a wholesale, or a retail outlet or wholesalers may have that particular requirements that then gets pushed down the supply chain, and then it's the growers that are required to introduce those kinds of practices, which does make it challenging then for smaller farmers to be able to meet those requirements. And so that's the example of where sometimes it can be a mechanism where only the larger, more sophisticated growers can meet those demands. But certainly it is something that can be addressed through capacity building, through technical training to ensure that safety standards are met. Yeah, because it is definitely something that consumers are increasingly concerned over. And nevertheless, we have also the domestic requirements that can be introduced based on that.
Well, thank you, Jeanette, and thank you also to our information manager, Gorgon, who is sitting behind the scenes as always, and to everybody who attended today. Thank you. You know, we appreciate your time. We appreciate your presence. There was one last question. It related to the presentation and to the webinar being posted, and also certificates. We do not issue certificates for the webinars, only from our seminars and our training courses. Secondly, the PowerPoint itself will not be made available, but the whole presentation will be posted on our website. So again, thank you to everybody. Jeanette, thank you to you in particular, of course, and many blessings upon everybody. And we hope to see you again soon. Thank you.
Thank you very much, everyone. Thank you for coming. Bye-bye.